are you guys? All right. Ms. Henney, you're up.
May it please the court, my name is Jean Henney and I represent the father who's the appellant in this appeal, and I would like to reserve 5 minutes for a rebuttal if I may.
Sure.
The trial court found, this is an appeal from an order denying the father's petition for a modification of time sharing. The trial court found that the father failed to meet his threshold burden to prove that there had been a substantial material, and the court added permanent change of circumstances. This finding, this directed verdict, was made despite the uncontroverted evidence that the young daughter had been the victim for several years of sexual abuse at the hands of the mother's husband. This is a matter, as a matter of law, an incorrect legal standard, and the sexual abuse of the child constituted a substantial change of circumstances as a matter of law. The trial court never got to a best interest analysis of the children, and therefore the father is requesting that this court reverse and for a best interest analysis. In 2014, a final—
Actually, it would be like to reverse essentially for a new hearing because the judge cut the hearing short, correct, on motion for directed verdict?
I'm sorry.
The court granted a motion for directed verdict at the close of your client's case, or waited till after the judgment and after the hearing?
Well, unfortunately, we don't have a court reporter.
We don't have a transcript, correct?
So
right.
we went through the steps necessary to create a stipulated statement or statement of the evidence in lieu of
Right.
transcript, which required 2 trial court hearings. So the procedural part is not perfectly clear, although the trial court does indicate that it is a directed verdict that he granted.
Okay.
So,
We don't know, but we don't know whether the mom actually put on a case in chief from our record.
The mother testified. We don't know if the father called the mother to testify or if
right.
the mother testified. Okay. It was a summary of the evidence that was presented that we could recreate and approved by the trial court. So yes, the case would go back because it was a directed verdict was entered on an incorrect legal standard. But the father would also argue that as a matter of law, that the abuse that this child suffered was a substantial change of circumstances. In the Myers versus Myers case, Judge Smith wrote for the majority that even a child witnessing abuse is a substantial change of circumstances justifying a modification if the best interest, justifying the ability to get to the best interest analysis. So there really is no question that the father met his threshold burden. The trial court's only reason for saying that father didn't meet the threshold burden was 2 reasons. One, that the stepfather was now in prison facing a life felony, and 2, that the mother didn't know about the abuse. Of course, what we're looking at is the child, not what the mother knew or didn't know. From the child's standpoint, there could be no greater substantial or material change of circumstances than what took place in her life for a period of several years. Now, interestingly, in the answer brief, the mother seems to take the position that, of course, the trial court found that there was a substantial change of circumstances, as he was required to do so, but that the directed verdict was to the issue of the best interests of the children. Well, this is incorrect for several reasons. First, the trial court told us why he directed the verdict. And if you look at record 232, the trial court says, the court finds at this point there's no permanent change in circumstances, as Mr. Calderon, as the change
will never be around the child.
Right.
And there's no admissible proof before the court that the petitioner knew about the abuse. The judge also seemed to, without using these terms, but say, you know, the this child is not going to suffer any harm in the future as a result of the incidents here.
Quite possibly the most disturbing sentence I've ever read in an opinion in an order in my entire life. When there was no,
Right.
and that's one of our arguments. There's no
I
competence.
mean, the therapist said she was doing well, but didn't say, as I understand, or the judge didn't write this in the judgment, that the child would not have any lingering effect.
Well, the child was doing well in Nebraska with the father.
Right.
Oh,
But,
you know,
but the judge seemed to hang his hat on, said she's doing quite well.
and therefore there's
and-
no permanent,
Right.
effects of this horrific abuse on the child.
Okay, let me raise that with you. By the time of the hearing or by the time of the judgment, the child had been in Nebraska for how long?
The child had been there since December.
And this was, I don't even know.
The hearing was in the fall of,
So the child had been there most of a year.
the mother had only had 2 weeks of supervised visitation.
In fact, the child is, I recall this correctly, and we hear a lot of these custody issues, but this all started with the mother complaining that the father had not returned the child after Christmas vacation, right? So the child had actually been in Nebraska since December anyway.
Yes.
And this was heard in the middle of November. So basically the child at that point had been in Nebraska for a year.
Yes.
Roughly.
Except for 2 weeks of supervised visitation in Florida.
Okay. And so the point I'm getting to is, and this judgment was entered in January of this year. If we were to reverse, the child will have been in Florida most of the year, correct? The stay motion was denied.
Well, the child has recently been returned to Florida. That is correct.
That's recent. I mean, well, okay. I don't want to be off the record, but do we have some concern that the best interests of this child will be affected by the fact of, depending on where she has been all of this time? I mean, would that be for a court to consider if we were to send this back?
Well, I think if this court sends it back for a best interest analysis, I think it's appropriate to take to give specific directions that additional testimony may be taken considering the best interest of the child. They weren't considered
Right.
at all.
Right.
And I think that the father would request a reversal with specific directions that a best interest or a new hearing.
Or that he had made a prima facie case of change of circumstance.
Yes.
That's what you're looking for.
And that a hearing be held within an expedited period, specific period of time. Another complication is that the trial judge has now been transferred to another docket. So new judges assigned here. We would request that this court give specific directions. We would request that it be specific directions that the sitting judge assigned to this case on the docket hear it. But if this court, what the father doesn't want.
Come back, that the judge assigned to the case currently hear it?
Yes, that on the docket. Yes. So that we don't have this period of months that go back and forth with the hearing. Who's going to handle it? They pass it back and forth.
I get it.
The time is of the essence. This child that undisputably suffers from post-traumatic stress syndrome has been returned to the place where the trauma occurred. Same house, same bedroom. And her best interests have never been heard. So the father does not want this case to linger on if there is a reversal and remand. And this more specific, the directions this court can give as to procedure will move it along much faster.
We get it. All right.
I really don't, to me, this is an obvious case. And I really don't have much more to say other than I can go through the best interest factors and say which ones the trial court missed and didn't do. But
he seems to never have gotten to that point.
Right.
According to his judgment. He rejected it based on failure to show a substantial and permanent change of circumstance.
Mm-hmm. And I think that the trial judge, he attempted to defend himself in one of the orders denying our motion for stay, saying that in the Dukes case that the court used the term permanent change of circumstances added in.
But that wasn't the issue in front of Dukes.
No. And
No.
it is in a permanent change of circumstances for financial purposes, for support or alimony, but it is not in time sharing. And the trial judge was just wrong, dead wrong. Needs to be reversed and remanded. I'll reserve the rest of my 5 minutes for rebuttal if there's no further questions.
Thank you, Ms. Henning. Mr. Spivak? You're muted, Mr. Spivak. You need to unmute. I do that all the time, and I'm happy to say that you were the first person who's done it today, but you know, today's not over yet.
I have been known to do that before as well. Your honors may please the court. My name is Scott Spivak. I represent the mother, SK, in this case. Judge, what has been left out by counsel, what has not been stated by counsel, is that in a modification of custody case, there's one person who has the burden of proof, and that is the move-in. That is the party coming forward. That is the party petitioning the court for a modification of custody. In this case, that was the father. In this case, if you look at the factual record, when you look at the factual record, and I agree with Ms. Henny, obviously there was no court reporter here.
Nor were either of you two there, correct?
That's exactly right.
Wow.
That's exactly right. But the only thing that could be done was to reconstruct the factual record of the hearing, and that was probably
done. I would suggest that, you know, at one level, even if that hadn't been done, you know, the error or what Ms. Henny complains of is basically on the face of the judgment. You know, in terms of there's been no permanent change. I mean, the judge made the fine, you know, clearly the molestation occurred. That's an accepted fact in the judgment, correct?
Yeah, yes, sir.
And so.
Yes. Here's the problem, one of the problems with counsel's argument. Trial courts, as this court knows, trial courts are confronted all the time with emergency situations where something has happened that causes the trial court to have to take immediate emergency action. In this case, of course, it was the abuse, the sexual abuse of the child coming to light. And the trial court did exactly that. The trial court took emergency action and issued an emergency temporary order that on a temporary basis transferred custody to the father up in Nebraska. And then, of course, the case was set for a final hearing. And it's at the final hearing that the burden of proof on the father then comes into play. And a review of the facts of the case demonstrate that that burden of proof wasn't met. Because while trial courts have emergencies that come up quite often that require temporary modifications of custody, just as the court did here, what the court then has to consider at a final hearing is exactly what the trial court considered here, which is what constituted the emergency and led to the transfer of custody temporarily to the father. Is that still an issue? Is that still a problem?
I frankly don't have the whole record in front of me here, but I can look it up pretty quickly. Certainly, the emergency aspect of it was not the basis for the petition to modify custody on a permanent basis, correct? I mean, we're not here. The judge is not saying, oh, the emergency's over, therefore, I do not find there's been a substantial change in circumstances. I mean, I don't see that that's a legal basis for making that finding.
No, Judge. I was pointing out the procedural history of the case. And when the court, in its order, used the word permanent, first of all,
he's saying that the emergency is not a permanent situation.
And literally in this case, what was in place, namely an abuser in the household, is no longer in place.
But when he says
the
judge is at the final hearing on a petition to modify, the judge isn't dealing with the emergency allegation. The judge is dealing with the petition for modification, correct?
That's correct. Yes, sir.
Well, Mr. Spivak, the order in paragraph 12 says, and I recognize why you may be trying to argue this factor of permanency wasn't an additional factor in the substantial change in circumstance test, but the court finds in paragraph 12, the court, at this point in time, there is no permanent change in circumstance. So I don't think, as you're saying, that the court is addressing this because this is a final hearing versus an emergency. I think this is a factor that the court has incorrectly used to have the parent here. An additional element of proof is this issue of permanency, because they've interjected, the court here has interjected the element of permanency. I don't see the confusion, the final hearing versus the emergency. I don't even know that the word emergency exists in that, and it may, it's not jumping out at me at the moment. But I think the court here posed an additional burden of proof. And
Judge, I certainly respect what the court is saying. I think that when a court is making a judgment at a final hearing as to whether there is a substantial change in circumstances, I think that it is certainly appropriate for the court to consider, well, what's going on right now with the child.
Isn't that something that the court can look at as far as whether it's material? It doesn't have to be permanent, right? I mean, you would agree that the cases don't impose upon a party the element of permanency in the substantial change of circumstance, unless we're dealing with financials and, right, alimony.
And Your Honor, I do agree with that. I do agree with that. Now the Dukes case did uphold a ruling by the trial court that used almost identical language to the trial court here.
Right, but Dukes, that wasn't the issue in Dukes. The Dukes didn't pass on whether the trial court's use of that term was a correct task. This had to do, it was just kind of almost in passing describing what the trial court said, right? It didn't really have anything to do with the issue in front of Dukes that it decided.
Well,
Having
I think
recently gone through Malik versus Malik, I know a lot. I'm pretty familiar with Dukes, and it doesn't say that a permanent change is required for a modification.
and I am not making that argument. I want to be clear.
And to say that we affirm the judge found these things, including that there was a permanent change. To say that you affirm that isn't saying that the permanency was necessary. It's just saying we're affirming the judgment, correct?
I agree.
Yeah.
I certainly agree with that, Judge Northcutt.
Right.
I do think, though, that that when a judge at a final hearing is hearing the evidence and hears that the abuser is out of the home, that the abuser is never going to come back to the home, that the abuser is facing years in prison and is in jail presently, that the mother filed for divorce from the abuser, and there's a final hearing set. I do think that all those things are part of what weighed into the court's decision to say there's no longer an issue here with regard to the child, with regard to the mother, again, having custody of the child. I think that it is appropriate for the trial court to take those things into consideration, and I think that that's what the court did.
Well, those things could have been taken in consideration if the court had done a best interest analysis, right?
I think that the court can take it into consideration on both prongs of the test, Judge Smith. I think that the court can take it in.
You're interjecting a permanency prong in the substantial test.
I understand the problem with the use of the word permanent. I do think when the court looks at the record, what the court can see is that what the trial court was saying is that the issue that had been present is now, at the time of the final hearing, no longer present. Therefore, there has not been a substantial change in circumstances. I think that the court can do that.
Obviously, though, that if we were to look at this through the filter of an actual best interest analysis, one might suggest that the absence of the perpetrator is not the only question that, issue that bears on the best interest of this child. And the judge seemed to have treated it that way. So I think even if we were to say, okay, he engaged in a best interest determination, one might argue that it was a fairly narrow view of what the best interest of the child might be.
And number one, I believe that's why, in fact, the judge found there to be no existing substantial change in circumstances that warranted a modification. But
the sexual abuse might not be repeated in the future, but as something that has occurred in this child's life, it hasn't gone away, has it? I mean, it's something that happened to her. It's clearly a very traumatic event.
Yes, it did, Your Honor. Yes, it of course happened. I do think, though, that that on the record here, it is the father that has that burden of proof, which the courts have described as an extraordinary burden in a modification case. And if when the court looks at the factual record here, such as it is, it's all we've got. What we've got is the father presented scant evidence. The father testified. His testimony was quite limited. Basically, his testimony was, I found out about the sexual abuse, and I put the child into counseling, and the child has been with me since.
And is doing quite well. And the evidence was she was doing quite well with him in Nebraska.
Yes, yes. And the counselor testified to that. But again, the counselor's testimony was very limited. The detective's testimony was very limited. In fact, the most extensive testimony that was given here by far on the factual record was the testimony of the mother. And there was nothing presented by the father, who has that burden of proof, that extraordinary burden in this case. There was nothing at all presented by the father to indicate that the mother knew of this abuse, that the mother participated in this abuse, that in fact the mother did anything wrong.
But that's not the end of the inquiry, is it? It wasn't that she didn't do anything wrong, it wasn't the mother's fault.
No, it certainly isn't the end of the inquiry. But the mother gave extensive testimony with regard to what did and did not happen, and what she knew and did not know. And that's all the case that was put on here by the father, who has the burden of proof. And of course, subsequently, the child has been returned to the mother, and the child at this point has been, actually both children have been back with the mother for quite a period of time. It's not something that has happened like in the last month or two. So I think that what confronts this court on this case is the father did not put on a case that we would submit in any way met the father's burden.
Well, it's hard for, so you're saying that we should find harmless error because the father didn't put on a case from which the judge could conclude that it was in the child's best interest to remain in Nebraska?
Well, I think that there are two things, Your Honor. First of all, it is the father's burden to present.
Well, I hear that. I hear that. And you're saying that the evidence that was presented wouldn't support a finding that was in the best interest of the child to stay with her dad in Nebraska?
I think that the evidence that was presented supports the finding made by the trial court.
But the trial court, of course, that is subject. The trial court only found there was no permanent change in circumstances. In fact, he didn't even find that there wasn't a change in circumstances. He found that it wasn't permanent, and he didn't go any further than that. So I don't think we could say that the evidence supported a best interest determination by the judge, because the judge didn't seem to make it.
Well,
And I don't know that
respectfully,
we,
Your Honor,
I don't know that we can exercise a judge's, fact finding and discretion to do that from here, particularly based on a reconstructed record.
Respectfully, Your Honor, I do think that the judge did not just say, well, I'm not finding that there's been a permanent change in circumstances. Boom, child goes back. The judge made certainly some extensive findings about what the situation was at the mother's home here in Florida, as far as the abuser not being present, as far as the mother and her lack of any knowledge about this. So I mean, I think that the judge did make a number of findings on that matter.
So it's enough to determine the best interest that she didn't know about.
And that the abuser is no longer present, will never be present, is being prosecuted, that the mother filed for divorce against him, and there's a final hearing that's set, that the mother stipulated that no one in her new husband's family nor the new husband would ever have any contact with the minor children. All of these things were matters that the court took up and were considered by the court and were part of the court's finding.
Mr. Civic, I understand that this stepfather's gone, but I mean, isn't the root of the problem that the child didn't feel comfortable going to the mother and telling the mother, and that she actually went to the stepmother? I mean, isn't that at the root of the real issue here? I mean, okay, so this gentleman's gone. So, but this happened in this household under her as the parent and the mother, and the child wasn't comfortable going to the mother. So isn't that in the enumerated factors something that the court could have considered and didn't even get there, because based on what we have here, it looks like the court stopped at permanency.
Well, I think that the factual record indicates what was before the court and what the court did consider. So I don't think that we can say that that was something that the court did not consider. But those facts certainly were before the court.
But you would agree with me that the root of the issue is something why the child wasn't comfortable going to the child's own mother and had to go to a step parent to tell what happened. And so by your argument saying that you've removed the perpetrator doesn't necessarily say that might not necessarily happen again. So.
Well, it wasn't, Your Honor, that the child, it wasn't, Your Honor, that the child only did not go to the mother and disclose to the mother. The mother had the child in counseling at I believe it was Tri-County.
There was another, I think, hypersexualized issue that the mother was aware of that was being investigated by some anonymous something.
No, that was. I'm sorry, Your Honor.
No, I'm just saying there was some other issue other than this that was being investigated. That
was, and it's not clear at all what the investigation of that was, but I believe that what the court is referring to is a past incident, a past matter. At the time that these matters, or shortly before these matters were disclosed, the mother had the child in counseling. I believe it was Tri-County. And the child did not disclose to the counselor at Tri-County either. So it's not a situation where the child simply did not disclose it to the mother. There were other people, including the child's counselor, that the child did not disclose it to.
But the child did disclose it to her stepmother in Nebraska.
That's on the facts.
Right. We have helped you use your time and a little more, Mr. Spivak. So we'll head over to Ms. Henney for her rebuttal. Thank you.
Thank you, Your Honor.
Ms. Henney?
I appreciate Judge Smith pointing out that the issue that the mother didn't know does not really work in the mother's favor. This child was the subject of sexual abuse of a horrific nature for several years in a home where the mother was a stay-at-home mother. And it was sort of heartbreaking to hear her testimony at the hearing to say the child was given her own bedroom and the sister moved out into a room where the sister now shared with two other siblings so that the child could have her own room because she was becoming a young woman. It just further facilitated access, unfettered access to take pornographic pictures and videos of the child using sex toys. I mean, we don't have the details of the abuse in this record, but we see it through Deputy Kistler's eyes. He was formerly a detective. He gave up a detective position because this case broke his heart. So it's not a one-time incident. This horrific abuse took place in the mother's home. So the fact that she was clueless does not work in the mother's favor. The father had one burden to prove to meet his threshold burden, and that was a substantial material change of circumstances since the original final judgment was entered. If this case doesn't meet a substantial material change of circumstances, then no case ever would. The father met that burden, and the mother seems to take a slightly different approach on oral argument now, because in the answer brief, she said, of course, the trial court found, as he was required to, that there was a substantial change in circumstances, but he made the directive verdict on the best interest. And that simply isn't the case. The father can't emphasize enough the importance that time is of the essence. This child deserves better from the legal system. She deserves to have her best interest heard. And we just request an expeditious reversal remand with the specific instructions as to time, nature of the hearing, who to preside over the hearing.
Okay.
Unless there's any further questions, I have nothing further.
Thank you, Ms. Haney. I have to say, Mr. Spivak, you did well under fire.
Thank you.
As you leave, the way you leave is to click the leave button in the lower right-hand corner of your Zoom screen, and then we'll call our next case.